Good afternoon and welcome to the Appellate Division First Department. I will commence with the call of the calendar. Counsel, please listen for your case. People versus Robert Johnson.
Claudia Troop on behalf of Appellant Robert Johnson. Good afternoon, Your Honor.
Good afternoon. You have 4 and 1. Respondent. Respondent, Mr. Tarbutton, are you there?
Yes, Your Honor, sorry. Michael Tarbutton for the people.
And you have been granted 4 minutes as well.
Thank you, Your Honor.
Tavares versus Ortiz is submitted. T. Rahim is submitted. Robles versus 635 Owner LLC. Ms. Coleman.
Yes, Your Honor.
Good afternoon. You've been granted 4 and 1. Mr. Fitzpatrick.
Yes, Your Honor, for Respondent Appellant.
Good afternoon. You've been granted 4 and 1. Smith versus Montefiore Medical. Mr. Turkin.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 4 and 1. Mr. Monnier III.
Good afternoon, Judge.
Good afternoon. You've been granted 4 minutes.
Thank you.
VA Management versus Estate of Sanjay Valvani. Mr. Hatch Miller.
Good afternoon, Your Honors.
Good afternoon. You've been granted 6 and 2, sir. Mr. Tremonti.
Good afternoon, Your Honors.
Good afternoon. You've been granted 6 minutes. People versus Ursel Lee, submitted. Shala versus Park Regis Apartment, submitted. Artists' Rights versus Robinson. I believe there is a pro hoc vici application. Mr. Mota, I will hear you.
Yes, Your Honor. I am a local counsel for the defendant appellants in this matter, and I would like to introduce Gerald Klein, who's an attorney admitted to practice in the state and federal courts of Georgia. He has also been admitted to practice before this court on this appeal, pro hoc vice. I asked the court to permit Mr. Klein to participate in this appeal and present oral argument on behalf of defendant appellants.
Thank you so much. That application is granted. Welcome, Mr. Klein, and you have been granted 6 and 2. Mr. Cordero.
Good afternoon, Your Honor.
Good afternoon, counsel. You've been granted 6 minutes. People versus Tycane Webb Thompson is submitted. Dean versus Broadman. Mr. Lyon.
Good afternoon, Your Honor. This is
Good afternoon. You've been granted 4 and 1. Mr. Hept. Mr. Hept.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 minutes. People versus Edwin Feliciano is submitted. 9th Space versus Goldman. Mr. Pauly.
Good afternoon, Your Honor.
Good afternoon. You've been granted 6 and 2, sir. Mr. Parnes.
Good afternoon, Your Honor.
Good afternoon, sir. You've been granted 6 minutes. Pagniott versus Moore, and apologies if I've mangled the name. Mr. Godosky.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 and 1. Mr. Mingione.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4.
Thank you.
Vioni versus Carrie Associates.
Good afternoon, Your Honor.
Good afternoon, Mr. Carrie. You've been granted 4 and 1. Mr. Stark.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 minutes.
Thank you.
Bartlett versus Tribeca Lending is submitted. iPayment Inc. versus Silverman. Bosquet Lambert.
Yes, Your Honor. Good afternoon, Your Honor. 16 Bosquet Lambert for Appellant iPayment.
Good afternoon, Ms. Bosquet Lambert. You've been granted 4 and 1. Mr. Kaplan.
Thank you, Your Honor.
Good afternoon to the court.
Good afternoon. You've been granted 4 minutes. Rodney versus City of New York is submitted. O'Neill versus Machitnik Golib is submitted. People versus Robert Johnson, first on the calendar. Ms. Troop, you have 4 minutes.
Good afternoon, Your Honors. May it please the court, Claudia Troop on behalf of Robert Johnson. Mr. Johnson is currently serving 2.5 to 5 years for taking a pair of shoes from a DSW store and pushing a loss prevention officer. At the time of his plea, he pled guilty to possessing a gravity knife and the robbery, third-degree count, and the people have now acknowledged that the gravity knife count should be dismissed. In light of that dismissal and a host of mitigating factors, we're asking that this sentence be reduced to 2 to 4 years. Mr. Johnson has, unfortunately, a drug history dating back to the time he was 11 years old.
This is Justice Moulton. I'm sorry to interrupt you, but there were 2 conditions when he was offered 2 to 4, and he didn't comply with either of them. He was rearrested and he didn't show up for his sentencing. So don't there have to be consequences for that?
Your Honor, we're not contesting whether he breached the plea agreement. Our point is that the sentence as imposed, even the 2 to 4, was a step up from the 1.5 to 3 that he had originally been offered if he had pled guilty. And also, Mr. Johnson attempted to get diversion and treatment in this case. His record is demonstrative of somebody who has suffered with drug addiction and has sought treatment, but has been unable to kick his addiction over the course of his adult lifetime. The prosecution acknowledged that during the diversionary intake, Mr. Johnson was forthright, and also that he expressed remorse for his actions. What this comes down to is somebody who is serving a lengthy sentence for stealing a pair of boots. And in light of the fact that the gravity knife count has been dismissed and that the original offer was 1.5 to 3, we're not asking for a lot here. We're simply asking for a reduction from 2.5 to 5 to 2 to 4. That might seem of little consequence to the court, but it's of great consequence to Mr. Johnson. He has family in Georgia who he would like to join in an attempt to become a law-abiding member of society and ultimately kick his addiction. By shaving off that extra year off the maximum, it means that he would be able potentially to rejoin his family.
Has there been some indication from the family in Georgia that now they are prepared to assist their family member when they haven't in all the years past, when he has such a lengthy record? And clearly, if you have a family member who has such repetitive criminal history, it's a cry for help. They haven't been willing to do so in the past. What is there to make us believe that they will now?
Well, in the pre-pleading memo, his cousin, who he is very close with and considers like a sibling, said that she's willing to help him and have him move down to Georgia with her and move in with her and give support that way. And so that perhaps getting out of New York City and being able to get out of this atmosphere, which has been so difficult for him, will help him kick this drug habit now. But I also want to mention that his history is really somebody who has struggled with addiction, and it's low-level property crimes and somebody who has resorted to stealing to support his addiction. And this is something where the original offer of 1.5 to 3 was withdrawn, not because any hearing was held or any witness was inconvenient, merely it was because of a refusal to take it or leave it at the time it was offered. And so because the sentence—
Counsel, I'm gonna let you finish those arguments on rebuttal.
Okay.
We're out of time, okay?
Thank you.
Mr. Tarbutton, you have 4 minutes.
Thank you, Your Honor. Your Honors, the defendant here is not simply a harmless shoplifter or just a drug addict. He has a very extensive criminal record, 6 prior felony offenses, 63 prior misdemeanor convictions, and a lot of these are violent. He has a rob 1 conviction, a conviction for attempted second-degree burglary. He has 2 convictions for menacing with a weapon, 4 convictions for assault 3. He's a violent man. He fought with a loss prevention officer in this case. He fought with a police officer who arrested him. And he negotiated the minimum legal term, 2 to 4. And then he reoffended twice before sentence. And even then, the court enhanced his sentence by only the smallest possible amount, by 6 months over the minimum. So on the whole, even the enhanced sentence of 2.5 to 5 years is remarkably lenient given his record and given the history of violence. Also, Your Honors, certainly he has a drug problem, but it's not clear what else can be done of this situation. He's had at least 2 inpatient residential drug treatment programs before that he's successfully committed, and he's gone back to commit crimes. He's had outpatient drug treatment. He's had supervision outside of prison. He's violated his parole 4 times, so supervision hasn't worked. prior periods of incarceration haven't rehabilitated him or deterred him. The only thing we can do to keep him from reoffending is to put him in prison again. And in this case, the judge did that for a very small period of time, for 2.5 to 5. In these circumstances, he could have gotten up to 3.5 to 7. So still, this is an appropriate just sentence. There doesn't seem to be much else that can be done with this defendant. As the argument too that he was somehow entitled to the 1.5 to 3, he turned it down, and it was only increased to 2 to 4 because the case was sent out to trial. He knew that was going to happen. His counsel explained at sentence the defendant knew that if the case was sent out to trial, that the offer would be increased. He wanted to go home on bail instead before he pled guilty, so he deliberately chose to do that. The record's very clear that he knew he planned to come back and accept the higher plea offer. So that the fact that the offer was raised, he ultimately accepted the 2 to 4, wasn't the result of surprise or of a misunderstanding. He deliberately did that, and now he wants the court to basically shield him from the consequences of his very deliberate decision. And this is before, of course, the fact that he reoffended and violated the terms of the offer here. Also, Your Honors, this wasn't any kind of vindictive trial tax. It's of course not uncommon for a plea offer to be withdrawn and a higher offer to be offered if someone is sent out to trial. People have to maintain the case in a trial-ready posture. In this case, we have been negotiating, considering him for an alternative to incarceration disposition for a year. Now, there's no record of this because the defendant didn't raise it below, but presumably he was waiving 30-30 time. Presumably we didn't have to maintain a trial-ready posture during that whole period. Once it's sent out to trial, we do. It's reasonable for us not to offer the particularly generous 1.5 to 3 offer we originally did when we don't get the benefit of not having to maintain the case in trial-ready posture. But importantly, Your Honors, because the defendant never raised this claim before, the prosecutor never had to defend the reasons for why we raised the offer when the case was sent out to trial. The court inquired about it and accepted the fact that it's sent out to trial as a reason. Defense counsel found it necessary to explain why his client didn't accept the 1.5 to 3. He never questioned the propriety of raising the plea offer when we sent out to trial. There's no record of this. And now defendant comes and accuses us of some kind of impropriety of raising the offer simply to punish him from going to trial, which of course he never intended to do to begin with. He didn't go to trial, and his counsel's comments at sentence make clear that he intended to plead guilty the whole time if he didn't get the ATI disposition. So he's very poorly placed to make this argument. And there's no thank you, Your Honors.
Thank you.
Your Honors, Mr. Johnson is now 55 years old, and this is ultimately just a shoplift that went a little wrong when he pushed the loss control officer. This is not something that a 55-year-old man with a history.
Except, Ms. Trubb, in light of his history, he knows the line not to cross to not escalate it from a simple petty larceny to a robbery. He knows. Okay,
But this is not a crime that deserves 2.5 to 5. 2 to 4 is still a significant sentence. And we're not saying he shouldn't be convicted of robbery. We're just saying 2 to 4 is sufficient to punish him. As far as his criminal history, most of those crimes are from, the more serious ones are from when he was much younger. He's older now, he's 55, he has an opportunity to join family in Georgia. He should be given, all we're asking for is a slight reduction to allow this 55-year-old man to rejoin society sooner rather than later.
Thank you so much. Robles versus 635 owner, Ms. Coleman, you have 4 minutes.
Thank you, Your Honor. May it please the court, Coleman from 200 Miller's Gallo.
Your audio is a little off.
Okay.
Okay.
Is that better?
We'll try. Go ahead.
Okay, Your Honor, thank you. I represent 635 owner, the defendant appellant in this case. Your Honors, 635 owner is entitled to full contractual indemnification here because the common law negligence and the labor law 200 claims conclusively determine that the only liability, if any, for 635 owner is going to be statutory and vicarious. And that determination made pursuant to a stipulation that was entered into by all parties, including the defendant respondent, and so ordered by the lower court. I think places this case very squarely within the long line of cases in this court that have come out of this court that hold very clearly that if there is no evidence of negligence, there's no claim here even of negligence, then full indemnification is warranted. This court very recently in Sunon versus Klein and also in Keogh versus Broadway reaffirmed that as being the law in this department and in the state. Keogh, I think, was a very, very on point case. It involved a ladder. The owner had nothing to do with the ladder, no control over the work site. And this court held there was no issue as to the negligence of that owner, and therefore he was entitled to full contractual indemnification. And I would just also like to briefly point out that in addition to being a party to the stipulation that dismissed all negligence claims against the owner here, there's no cross-claim asserted by the co-defendant respondent asserting the claim of negligence against my client. And we would respectfully request that the lower court's decision be modified to award our client full contractual indemnification.
Thank you.
I'll see the rest of my time back to the court unless there are some questions.
Okay, well, you have a minute on rebuttal.
Thank you, Your Honor.
Mr. Fitzpatrick?
Thank you, Your Honor. Good afternoon. The owner's motion for contractual indemnification should have been denied. The contractual provision states that it is triggered based on evidence of W5's acts or omissions. There is no finding of negligence or claim for negligence as against W5. No one knows who owned the ladder or who set it up. Plaintiff testified that he didn't know who set up the ladder.
The indemnification provision require negligence on your part or an act or omission, because that's much broader than negligence.
It states negligent acts or omissions. And there's been no evidence, and the owner has not pointed to what the negligent acts or omissions of. It states acts or omissions or other conduct of contractor. No one has ever pointed out what the acts or omissions of W5 were that allegedly caused this incident when the plaintiff.
Well, it doesn't limit it to just W5. Doesn't it also include the conduct of employees, subcontractors, or agents in connection with W5's performance of the work?
Calvin Maintenance is alleged to have been the employer. There is a separate issue and appeal of the special employee status of the plaintiff, but there was no written agreement between W5 and Calvin Maintenance, nor has there ever been any showing of what the acts or omissions of the plaintiff were. Even if one were to concede that Calvin is a subcontractor as the employer, no one has ever shown what the negligent acts or omissions of Calvin or the plaintiff were. He testified that he merely descended a ladder that had already been set up. Nobody knew who set it up the day before.
I'm a little confused because I thought the issue on this appeal was whether or not the owner was entitled to a conditional indemnification or an unconditional indemnification. I didn't really see briefed the issue of whether or not the owner was entitled to any indemnification, and I didn't see that as one of the issues on appeal. One appeal was 635 owners saying we should have had unconditional indemnification, and then there was your cross appeal having to do with contribution and common law indemnification. So where is this issue being argued, which you're now arguing before us, that there shouldn't have been contractual indemnification because there's no negligence on your part? I just didn't see that as part of the appeal being argued.
Point one in our brief argues that indemnification should not have been granted on summary judgment. In addition, in opposition to owners.
Appeal as to that? Did you have a course appeal as to that particular issue? Was your course appeal limited to the issue of contribution and common law indemnification?
Our cross appeal argues dismissal of the common law and breach of contract claims.
So I'm a little confused because the court, so you didn't appeal on that issue. You only appealed on the common law indemnification, and the court below granted conditional indemnification, and they appealed to argue it shouldn't have been conditional, but you don't have any cross appeal as to that. So if the only issue we're considering is whether the contribution should have been conditional, indemnification should have been conditional or absolute, why would we even be addressing the issue of whether or not you were negligent?
But it never should have been granted on summary judgment.
You didn't on that issue. That's what I'm confused about. If you had cross appealed and said not only should the plaintiff or the owner not have gotten conditional indemnification, the owner shouldn't have got contractual indemnification at all because we were not negligent. But I don't see that cross appeal, so I'm not sure how we get to address that issue in the absence of a cross appeal of that issue. That's what I don't understand.
In addition, contractual indemnification, the way it was decided by the lower court, although they didn't say conditional, owners characterized it as conditional indemnification.
They granted indemnification. However you want to term it, they granted indemnification. You didn't appeal that determination. So if you didn't appeal that determination granting indemnification, how can we, on this record, reach the issue of whether or not your client was or was not negligent, thereby triggering any indemnification, which is what you're now arguing to us? I think it's a good argument, but I just don't see how we can consider it because you didn't appeal from that determination. So could you address that specifically?
Specifically, the question of whether they should have gotten any indemnification at all, I believe, is the issue. They're saying that they're entitled to full indemnification. The court granted indemnification and said it would be determined the extent by how much they were negligent.
And you didn't appeal that. So again, I'm not hearing an answer to my question. If you didn't appeal that.
Instead of appealing, did you instead just oppose their request to grant full indemnification without a condition?
We're opposing any indemnification.
But you see, the problem that you're having, which is why my colleague continues to ask you the same question in a different way, trying to get you to answer it, is that in order for us to consider it, there would have had to be a cross appeal. And so my question to you was, and it is a friendly question, whether you chose to oppose the 635's motion to their appeal of the court's conditional grant. And so rather than cross appealing, you just oppose that?
I believe that our brief addresses that we're appealing the granting of their indemnification and also opposing what they're requesting to be granted the unconditional indemnification. So I believe we are appealing that issue as well in our cross appellant's brief, that it should not have been granted, which we argued because there's no evidence of the indemnification clause being triggered in the first instance. And then separately,
you will have 1 minute. I would suggest that you look to your papers and tell Judge Kern when we come back on your 1 minute where exactly you make that argument. Ms. Coleman.
Thank you, Your Honor. Your Honor, I would just stand on our briefs, and I would agree that that issue is not before this court.
Counsel, can you ask that specifically whether or not that issue is or before this court, whether or not this court should be considering whether there was any negligence on the part of your co-counsel's client, which would have triggered the indemnification? Is that an issue we should be considering on this record?
I argue that's not an issue that should be considered. I don't believe that that was part of the argument below. And furthermore, I mean, it's not briefed here. but the indemnification clause that was part of this agreement is the broadest possible indemnification. It doesn't require, as counsel started to say in his argument, it doesn't require an act of negligence specifically by them.
What is the language of it? Is it any and all acts with no negligence trigger? Is that what you're saying?
Yes, that's what it says. I mean, it says as a result of the acts or omissions or other conducts of the contractor or any act or omission or other conduct, officers, directors, employees, subcontractors, or agents in connection with the contractor's performance of the work.
So there's no language to do with negligence to trigger the indemnification.
I don't believe that there is. No, I don't see it here. I'm looking.
What page?
It's on page, quoted on page 5, going over to page 6 of Appellant's brief.
Thank you.
Thank you, Your Honor.
Thank you. Mr. Fitzpatrick, you have a minute.
Thank you, Your Honors. On page 2 of our brief, we argued that the lower court decision should be reversed as to summary judgment on the cross-claim for contractual indemnification.
Counsel, but it's not enough to say it in your brief anyway. It has to be part of your actual appeal, notice of appeal. But where is the language that you are relying on that to support your argument that the indemnification requires negligence on your client's part, as opposed to it being a more broad? Because the language that your co-counsel just read, and I will recheck if it seems to suggest a much broader indemnification. Can you read to me the language you're relying on that supports indemnification only being triggered based on negligence?
Well, the most broad language would be arising out of the work, which is not contained in this indemnification provision. It specifically states it has to be.
Language in the indemnification provision that you say supports your claim, it's based on a negligence trigger.
The provision states it has to arise out of the acts or omissions.
That's not negligence. That's much broader. So there is no negligence language, you're saying?
I don't see it in the provision, but there's never been any showing of what the acts or omissions of W5 were to trigger the clause.
The latter.
I'm sorry?
Nothing. It gave the latter. Okay, thank you.
The plaintiff didn't know who supplied the ladder. There was testimony that the non-party Calvin provided the ladder, and nobody knew who set it up. So there was never a showing of what acts or omissions, and it is being appealed in our brief and our argument that the lower court should not have granted summary judgment on contractual indemnification. And very quickly, we're also—
No, you're out of time, sir. Thank you.
Thanks.
Marcus Smith versus Montefiore Medical Center. Mr. Turkin, you have 4 minutes.
Good afternoon. May it please the court, I'm Jason Turkin from Montefiore Medical Center, the appellant. And I think what this really comes down to is whether the hospital had constructive notice of an alleged patch of ice in this location far underneath the overhang of a hospital building. I gather that the court has seen the photographs and that this location was not out near the sidewalk of Montefiore Medical Center, but was a very, very long distance to the interior, down a pedestrian ramp and a vehicle ramp, under at least 23 feet of cover of an overhanging building. And so our argument—
Yes, but the sides were not covered, counsel, and according to the record, there was about 18 feet of available space between the top of that cover and the ground floor, because there was only 5 feet of wall space that provided any kind of cover from side wind.
Your Honor, that's actually, with all due respect, it's really the other way around. The opening along the top, the breezeway, was 5 feet open, and you can see it in the pictures, when you look at them, you can see what anything blowing in there, how it would have to get in and how far it would have to go. It would have to come through this 5-foot.
Well, I mean, snow is minuscule, so it's not like snow and rain can't project sideways when there's wind.
It can project sideways, Your Honor, except that here it was a 5-inch snowfall, not a big snowstorm. It happened the day before, and you wouldn't expect it to go sideways 23 or 30 feet. And the engineers who worked there had never seen it land there. Plaintiff's expert meteorologist, he doesn't say it landed.
One of your witnesses acknowledged that there has been occasions when that occurs.
No,
your witnesses.
What the witness acknowledged is that if you go up as you go up the ramp, either the vehicle or the pedestrian ramp, you get closer and closer to the big opening by the street that, a vehicle, for instance, has to be able to drive into. So clearly that's very open. So what they acknowledge, I know exactly the point you're talking about, Your Honor. He said, yes, there has ever been snow that got on the ramp. He said in those very, very big snowstorms. Sure, in my 40, whatever it was, he said 48 years, snow has gotten there. Actually, that building hasn't been there for 48 years, but putting that aside, snow can get to the beginning of those ramps because it's up near that big opening. He was never asked, do you mean, down at the bottom where, as you go down there, you get further and further underground and undercover. So the witnesses admit that, yeah, up at the top, they have to clear it, but not all the way down by the emergency room.
Can you tell me where in the record there's an affidavit from either of your witnesses attesting to when was the last time anyone inspected the area of the fall prior to the accident in keeping with our precedents?
No, Your Honor, but I can't accept.
Haven't we held that that is fatal to a motion?
I think it is. Your Honor, I agree with you. It's fatal in certain kinds of cases. But in this case, it's very specific. This is a snow and ice case. This falls, the plaintiff made no question that this is a snow and ice case. And the cases about snow and ice indicate that, you have to at least be able to show that this would be a place that snow would naturally accumulate. For instance, if they were saying that the snow and ice gathered.
What case law says that?
All the case law on snow and ice
really
says that it has to do with gravity and weather. If it would be so, for instance,
Counsel, you have about a minute left.
Okay.
I have a quick question, Counsel. Why isn't the plaintiff's testimony enough for that? He said it saw dirty snow and ice right there.
Well, the plaintiff has offered 2 different locations. He said he saw dirty snow and ice at the bottom of the, pedestrian ramp. We don't agree that it was there, but putting that aside, he then filed the note of issue and he served photographs. And he's in the photographs pointing to a different location about 7 feet away from the bottom of the pedestrian ramp.
Well, that's actually cross-examination, but that's just about credibility, doesn't it? Just only go to credibility?
Well, I don't really think it goes to credibility because I don't really think now that he's admitted that the location was somewhere. I'm not talking about the credibility issue that you've said it's 2 different places. He now admitted in a notice to admit that it wasn't in the first place. It was over there on the blacktop about 7 feet away and not even in the direction of the emergency room, but the other way. So he never said that the snow and ice was in that location. If you go back to his testimony, he says that the snow and ice reached, down to somewhere down towards the bottom of the ramp. And actually, he said once he got to the place where he slipped, he didn't exactly see snow and ice there. He said he had seen it as he came down the ramp, and it's sort of unclear how far. But even if you accept that, he then changed after he filed the note of issue. He changed the location. He never said he saw ice gathered at that location.
You have 1 minute on rebuttal. Mr. Monnier, you have 4 minutes.
Good afternoon. May it please the court. Phil Monnier for the plaintiff, Marcus Smith. I think the court's right in asking questions about whether or not the defendant made a prima facie showing for entitlement to summary judgment. There's no evidence when the last time the area was inspected occurred, what the observations were at the time. There's no maintenance records, no inspection records, and there's no evidence that the practices even stated in the affidavit by the Director of Engineering were actually followed on the date of the accident. And this court's precedent is clear that those things have to be shown in order for the court to even consider granting summary judgment to the moving party. Not only that, but most of the arguments raised by the defendant on this appeal and in the motion below are more properly presented to the jury or during cross-examination or supported by the evidence during closing. That includes attacking the expert's credibility. It includes attacking the plaintiff's alleged inconsistency in where the accident happened. And most importantly, there's an inconsistency between their employee's testimony and his affidavit, which is said to support their motion for summary judgment in respect to when he was asked, he was shown the photographs of where the accident happened, and he said that he had seen snow and ice in that area in the past. And in his affidavit, he says he's never seen snow and ice in the area where the accident happened. So, I mean, that alone cannot support their motion for summary judgment. Clearly, there's an issue of fact based upon our experts' submissions that snow is capable of accumulating in the area where the accident happened in the event of high winds above 25 or 20 miles an hour. And our weather expert said that during the snow event the day before, 19 hours before the accident, there were gusts of wind up to 25 miles an hour. So based upon all that, I think the court below correctly denied their motion for summary judgment. Unless there's any questions, I'll rely upon my papers.
Thank you. Mr. Turkin, you have 1 minute.
Your Honor, plaintiff's expert, the weather expert, said that snow could get there in certain places. The expert certainly has the credentials, and in fact, we never attacked either expert's credibility. But the weather expert said that snow could get in certain places. And that's obviously true, since some of the places are right up by the sidewalk and completely open. So there could be no argument about that. He had the ability, he's got the background and experience to say that snow and ice could have gotten to that location, but he didn't say it. And I think it's obvious the reason that he didn't say it is he couldn't make it out to be so scientifically. He did say that there were occasional, and this is what he put, occasional wind gusts the day before and on this day, but he didn't explain that the wind gusts would have brought the snow to that location. And in fact, he gave the wind direction a direction opposite to which you would have needed to blow the snow into the building and to that location. The other expert never said anything about wind direction or anything else. He just says that in his experience, it can happen and that's it. I would submit that according to for instance, we cited the Simmons case. That indicates that you need to know the origin of the specific ice condition. Even plaintiff's meteorologist said you need a melting situation. It would have to get in, sun shines on it if it never gets above freezing, which it didn't, and then it melts back into ice. But in the affidavit, he never has sun shining in that location to melt it back into ice, because as anyone can see looking at the location, you will never have sun shining there because the sun simply can't get there. So he doesn't say in the affidavit that the
only way that ice melts is with sunshine, not the increase in temperature above freezing.
No, the temperature didn't. No, Your Honor, the temperature never increased above freezing in those hours. It was always highest in the 20s. It was a freezing.
Well, it's not just those hours. It's within a 24-hour period.
That's what I mean. In the whole period.
Counsel, I am still talking.
Sorry, Your Honor.
Thank you. So there are times when you have freeze, melt down, freeze, and that happens a lot.
That's true. Okay. But it didn't happen here because it was freezing the entire time.
Thank you so much. Your time is up.
Thank you, Your Honor.
VA Management versus Estate of Sanjay Valvani.
Thank you, Your Honors. Mark Hatch-Miller from Sussman Godfrey for the plaintiff appellant. The first of the four key issues in this case is that the disgorgement remedy that plaintiff seeks, the primary remedy plaintiff seeks, is equitable. There are cases going way back into history in New York and elsewhere that a claim to disgorge unjust compensation.
Mr. Hatch-Miller, I'm going to ask you to wait one moment. It appears my colleague has lost her connection, and I want her to have the benefit of your arguments. So give us a moment while she logs back in, okay?
Okay, Your Honor.
I'm back.
All right, you may proceed, Mr. Hetchmiller.
Thank you, Your Honor. So, Kate, there's lots of history in our briefs about the equitable remedy of disgorgement. I won't repeat that here, but practically, damages claim would be if you prove that there was a particular injury caused to the plaintiff by the defendant's conduct. This is a faithless servant case. It's a company suing its fiduciary for violating company policies, here engaging in insider trading, and then failing to disclose the possession of inside information, and otherwise violating corporate disclosure policies.
Counsel, this is Justice Moulton. You would concede that the complaint alleges no further trading activity after 2011?
Correct.
Okay, thank you.
Yeah. After 2011, Your Honor, what we have are claims that are separately pleaded, and you can see this in the record at page 24. I believe it's, I think it's paragraph 57, but don't quote me, in the complaint that describes that one of the bases for the claims is that the defendant was required under corporate policy to certify that he had not been in possession of material non-public information, was required to disclose any insider trading conduct annually. And there we have described in the complaint through 2014 written certifications.
Right, so you claim that those are ongoing acts, correct, if I understand your argument correctly?
Correct, Your Honor. And so even if you don't agree with us that there's a 6-year statute of limitations, we get a six-year statute of limitations plus tolling if you agree with us.
This argument assumes, though, that you're going to get your 6-year statute of limitations rather than a 3-year statute of limitations. Is that correct?
That's not true. We do have claims from the employer. This employee continued to work for the company until 2016.
But if you count certifications and you apply a 3-year statute of limitations, isn't it still untimely?
As to the 2014 certifications, yes, but we pleaded a claim that the defendant breached his fiduciary duties in 2015 and 2016 by omitting disclosures. The disclosures were required under the corporate policy manual, which is described in the complaint. We don't have, and we didn't plead written certifications of compliance from 2015 and 2016, but there is a clear record, and it's pleaded that there was a corporate policy that required these disclosures to be made. And there are numerous New York cases, especially I think the Kaufman case, which support that omitting a required disclosure that's required under your corporate policy is a breach of a fiduciary's obligations to the company. And so whether it's in writing or not, there is a claim for misconduct in 2015 and certainly in 2016, which doesn't require the 6-year limitations period. That claim that there was a breach of fiduciary duty by omission of a required disclosure in 2016 was overlooked in the defendant's briefing. It's not addressed in the decision below, and the court will need to address that as one of the 4 issues here.
Except that argument, the statute of limitations would never run now, right? Because until it stopped working, because there was always an omission forevermore till the day he committed suicide.
So, Your Honor, that claim would only be viable as to the compensation that the defendant earned in 2016. We're not saying that extends the limitations period back. It's just that there's a $6 million payment that the defendant obtained that year by failing to, and he only obtained that payment because he failed to make required disclosures that were required to be made each year. There's another issue, Your Honor, that's not addressed in the decision below, which is the claims here sound in fraud, and that's an independent reason, separate from the equitable remedy, why a 6-year limitations period applies, and that's
be the misrepresentation that you relied on that would be sufficient to justifiably relied on. that would be sufficient to invoke a fraud claim?
Well, two things, Your Honor. First, insider trading is fraud. It is a claim. Insider trading claims under federal law, they're brought under fraud statutes. Insider trading is secretly possessing information and trading on it that other people don't have access to.
How did the company rely on any misrepresentation that he made? What was the company's reliance on it?
Your Honor, certainly the 2014 certification of compliance with corporate policies, that is a specific false statement as to the company. I have been in compliance while working for you.
How did the company rely on that statement in any way, shape, or form?
By continuing to employ him rather than terminating him. And we've specifically alleged in the complaint that the corporate policies regarding insider trading specify that a potential consequence of engaging in insider trading or failing to disclose possession of material non-public information is termination. So that is an issue that will, of course, have the burden of proving at trial. But in our view, the facts will support a claim, and it's certainly pleaded sufficiently to withstand a motion to dismiss, that the plaintiff would not have continued to employ this individual further had he truthfully certified that he had in fact possessed non-public information, not only possessed it, but traded on it.
Okay, you have 2 minutes on rebuttal. Mr. Tremonti, you have 6 minutes.
May it please the court, Michael Tremonti for defendant respondent estate. I'd like to begin by picking up on the point about insider trading being fraud. While insider trading is often characterized as fraud, here it is not, and is not pled in the complaint to have been a fraud on the company. It is instead a fraud on, if you will, the counterparties to those trades or to the market. And to the reliance point,
well, isn't it also a fraud on the company insofar as once it was discovered, they were held responsible for their employees' conduct, and they had to pay fees and penalties, etc., as a result of that fraud?
So, Your Honor, a couple of things about that. I think, number one, the case law is fairly clear that these effects relating to the discovery of wrongdoing by an employee or expenditures that the company is required to make in order to deal with the fallout, in cases like this, those are incidental to the conduct that gives rise to the breach of fiduciary duty cause of action. So here you've got, to Your Honor's question, insider trading that's alleged to have taken place between 07 and 11. And then you have also alleged effectively omissions, which amount to concealment in subsequent years after the fraud has stopped. And those subsequent acts, the subsequent conduct in the years after 2011 are all under a very substantial body of case law held to be incidental to the underlying conduct. I'd also like to address the point about the calculation of the applicable statute of limitations. I think Justice Cohen in the well-reasoned decision did it exactly what was called for here. He pointed to the access point case of this court, which together with IDT sets forth precisely what is to be done when a court is attempting to decide how to calculate the statute of limitations in a case like this. And the touchstone, which Justice Cohen points to, is that whether you have the 3-year under 214.4 or the 6-year under 213.1 depends on the substantive remedy that the plaintiff seeks. And that's important because Access Point and IDT are not conducting an exhaustive survey of all the cases that characterize remedies as equitable or not equitable. Instead, Access Point and IDT specify you look to the substantive remedy, you look to substance, not form. And the
only thing that's being sought here is money, right? I mean, that's the only thing that's being pursued in this case, right? So
That's exactly right. And that's the definition in access point. It says, look, it's money damages if the relief, quote, could be accomplished simply by awarding the plaintiff a judgment against the defendant in the amount of funds that it had paid out. If it satisfies that definition, then it's not going to give rise to the longer statute of limitations. And in this case, what is alleged in the complaint is precisely that. Namely, this company hired a whole bunch of traders. They would go out and make trades, and hopefully those trades make money. All that money comes to the company, and if the trades are profitable, the company shares a specific amount of dollars with the trader. That's what happened here. The company took some of its profits, gave it to Valvani, and it now wants exactly those dollars back. So from our perspective, and from the court's perspective below, you've got a situation in which the definition set forth in access point and IDT is clearly satisfied, end of analysis. And this is a very practical and workable way of determining what the substantive remedy is.
Now, so what's your argument with respect to their claims, not only about the certifications, but also about the lack or omission of providing this information? So their argument that basically the statute of limitations just keeps not accruing, finalizing.
So I think that the appellant tries to get at this in a couple of different ways. For example, by alleging that the acts of omission after 2011, after the insider trading is all done, constitute continuing wrongs, right? And again, what the law of this court has said time and again is that where you have an end to the conduct that gives rise to the breach of fiduciary duty claim, as happened here in 2011, and then you have effectively omissions that amount to covering up or not disclosing the crime, those subsequent omissions are not independently actionable. They do not give rise to new causes of action. And as the court pointed out just a few minutes ago, you realize that if they did, you would never have an end to the statute of limitations, because any fraud that wasn't affirmatively disclosed by the perpetrator would indefinitely toll the statute of limitations by these acts of omission. And if I may, I know I don't have much time left. I just wanted to talk about—
You have no time left, but I'll give you an extra 30 seconds.
Okay, thank you very much, Your Honor. I just want to say very quickly that this court's decision in the VA Odeon case of just a few months ago, where you decided late in 2020 that the plaintiff's claims here against third parties were barred by imperi delicto, and the adverse interest exception did not apply as a matter of law where the corporation profited from the wrongdoing of its employees, equally applies here to bar the claim, separate and apart from the statute of limitations question. Thank you very much.
Thank you so much. Okay, Mr. Hatchmiller, you have 2 minutes.
Thank you, Your Honor. To touch briefly on in pari delicto, Your Honors, there's an exception to in pari delicto where an employer sues its own employee for misconduct. Here, this is not a third-party case like the VA Management versus Odeon case. Yeah, Your Honor, Justice Manzanet, you were on the panel in a case called New Greenwich that discusses this exception. It's not, you don't impute the employee's conduct to the employer when the employer is suing the employee for deceiving the company. Turning back to the limitations point, the claims that this defendant signed false certifications to his employer and omitted required disclosures in years thereafter, certainly at a minimum, those claims, which seek $60 million in compensation and $6 million from 2016 alone, are timely, either under a larger amount under the 6-year limitations because those claims sound in fraud, or the $6 million amount, those claims are still timely even under a $3 million limitation or 3-year limitations period. And Your Honor, we're not asking for the court to extend the statute of limitations backwards. All we're saying is that, as in any case, for example, like the Kaufman case, where there was a business opportunity that the defendant had, and he failed to disclose it to his partners as required. That misconduct, failing to disclose required information or lying about compliance with company policies, is itself breach of fiduciary duty. The time when that additional misconduct occurs, there is a viable claim for the return of the compensation for that period. Our claim is not that we get the benefit of tolling to go backwards in time, just that we have the ability to sue the employee for false statements and claw back compensation from the period of the false statements.
Thank you so much.
Thank you, Your Honor.
Thank you.
Artist Rights versus Robinson. Mr. Klein, you have 6 minutes. Mr. Klein, if you're speaking, you have to unmute. Mr. Klein. Okay, I am afraid I will have to go on to the next case. I will come back to this case at the end of the calendar. My apologies to Respondent's counsel, but I cannot help this without appellant counsel. Dean versus Broadman, Mr. Lyon.
Good afternoon, Your Honor, and may it please the court. My name is Christopher Lyon. I'm with the law firm of Goldberg Segala here on behalf of the appellants Howard Broadman, CPA, and RBSM LLP, who served exclusively as tax preparers for the respondent, Big Machine, and had no auditing role and did not provide any assurance services to the respondent. There are two remaining causes of action here against the appellants in this matter. There's a professional negligence claim, and there's an aiding and abetting a breach of fiduciary duty by the Taylors, who were members of the LLC. As far as professional negligence goes, there's no legal duty that's owed by a tax preparer to ensure that the transactions from the relevant tax year were authorized at the time that they occurred according to a tax client's operating agreement. The transaction already occurred, and whether authorized or not, must be properly accounted for. Professional negligence against an accountant requires a deviation from the recognized and accepted professional standards for accountants. Courts often look to professional authorities, and in the case of accountants, that's the AICPA. They've promulgated the Statements on Standards for Tax Services, or SSTS, which requires that tax preparers make inquiry as to whether a condition has been met if a transaction appears incomplete, incorrect, or inconsistent. It does not require further inquiry if it appears unauthorized. The required conditions that are envisioned by the SSTS relate to the IRS conditions for tax preparations, such as maintaining books and records or substantiating documents for transactions, not conditions of a private agreement. Other authorities echo this, including the Treasury Department's Circular Number 230, New York's regulation on the duties and responsibilities of tax preparers under 20 NYC-RR Section 20.
Counsel, did opposing counsel's expert point to any provision that your client deviated from in terms of the standards for tax preparers? If that's your position.
Sorry, I did not mean to interrupt you. My adversary's expert generally cited to Circular Number 230 and the SSTS and interpreted them in a way that does not make sense. He concluded that the accountants here violated those standards, but did not explain how it actually violated those standards. And what's at issue here is whether the accountant owes a duty to go to the operating agreement and enforce the limitations that are contained within the operating agreement. That is not a requirement of any of the authorities that apply and create the legal duty of accountants. In fact, the Internal Revenue Code's penalties provision specifically states that a tax preparer is not required to review business operations or documents, which would include an operating agreement. So where the accepted standards do not impose a duty to enforce the operating agreement, no legal duty would be owed. As far as the aiding and abetting a breach of fiduciary duty claim, there's two other elements in addition to the one that matters for purposes of this argument. That's the knowing participation argument. Knowing participation requires actual knowledge and substantial assistance. In order to have actual knowledge, you would have to know that the breach of fiduciary duty occurred, which would require, in this particular instance, actual knowledge that the transactions were not authorized. That's absent here. So there's no actual knowledge. In addition, there's no substantial assistance because you can't provide substantial assistance by providing routine business services, such as accounting, tax preparation services, which includes reconciliation of the accounts. I see that my time is almost up.
Yes,
and
your time is up and you have a minute on rebuttal, okay?
Thank you, Your Honor.
All right, Mr. Hepp, you have 4 minutes. You came in and then out.
Can you hear?
Mm.
Oh, I'm sorry. Here I am.
There you go.
For the plaintiff respondent. With regard to the professional negligence claim, the defendant appellant has argued that the court must decide whether a duty is owed. And as you just heard, Mr. Lyon has gone through all of the different professional standards, but what he's ignoring is the fact that each side submitted expert reports on whether or not Mr. Broadman owed a duty to make inquiry with regard to the payment of distributions.
Can you hear me? This is Judge Kern. Can you hear me?
Yes, I can. I'm sorry, Your Honor.
Okay, so my question is, I looked at what your expert stated was the departure, and I didn't see anything specifically which talked about a duty on the part of an accountant who's a tax preparer to check whether an operating agreement is authorized. I mean, whether a transaction is authorized or not authorized by the operating agreement. So can you tell me where in your expert's report they opine specifically on that issue, as opposed to what I did see, which is that if there's an obvious error, you have to look into it?
Yes, Your Honor. I'm looking at the affidavit of Eli Hoffman, and in his affidavit, he talks about the fact that under professional standards, a tax preparer is entitled to rely on information provided by the client unless that information on its face raises questions as to whether or not it's legitimate.
But counsel, on its face raised, because as I understand your argument, you're saying they should have made a determination as to whether or not the transaction was authorized by the operating agreement. But what on its face would indicate that there was anything improper as to this information?
Well, leaving aside the fact that the operating agreement specifically required a unanimous consent of all the members, and that the tax preparer, Mr. Broadman, had that agreement and read that agreement specifically because the agreement could
Counsel, are
contain
you
information
suggesting that now a tax preparer has to ask for the minutes of every board meeting of any entity that they do taxes for and cross-check the operating agreement of those entities against their minutes to see whether every transaction was authorized?
Absolutely not. That's not what we're
So then
suggesting at
again,
all.
what was it about this particular transaction that would have alerted this accountant that they had to do something extra?
Because he read the agreement, the operating agreement, specifically to find provisions regarding or that would be relevant to tax preparation. The payment of distributions and guaranteed payments are clearly relevant to tax preparation. And his denial that he read those provisions raises a question of credibility. In addition to that, and
even if he read them, it's a different issue that he knew. Let's assume for arguendo that he read them and he knew that. That still doesn't mean he has an obligation to go check whether in each instance it was or was not approved under the guidelines you've cited. That's where I'm losing the thread of your argument.
Okay, let me explain that further, Your Honor. I'm sorry for the confusion. Here, he not only did he review the transactions that had already occurred, as Mr. Lyon argues, he actually assisted the client in reclassifying transactions as distributions and actually entered transactions into the company's accounting system himself as
But
distributions.
tax preparers do that all the time in order to flag deductions that might cause an audit by the IRS. So that is the job of a tax preparer, to look through your how you have separated your deductions and advise you. You know, I think this one is going to cause a problem. But
No,
how does that translate into this must be a fraudulent transaction that wasn't authorized?
No, Your Honor, your question is missing the point, with all due respect.
Thank you so
Mr.
much for
Broadman,
that. That is
I'm
always
sorry, Your
so
Honor.
appreciated, but continue.
I apologize. I didn't mean to be flip. Your Honor, the accountant here was aware of the restrictions because he read the operating agreement. But more importantly, the payment of distributions in these cases, in every case, every year that he prepared the tax returns, the company was insolvent as a result of those distributions. And that's a violation of New York LLC law. And Mr. Broadman is also an attorney. He graduated from Fordham Law School. He was certainly aware, or should have been aware, practicing in this area, that payment of distributions in this case, where the company is insolvent as a result of the distributions, is inappropriate. Yet he never,
You're saying
ever
this is an accounting responsibility? A tax preparer responsibility?
He should have been he should have been aware of it, of
Isn't
the
this
issue.
a tax,
and he
isn't
should have.
this a tax claim? Isn't this a preparer claim, a negligence claim against a tax preparer? It's not a legal malpractice claim.
I'm not suggesting that it is a legal malpractice claim. I'm suggesting, though, I'm actually stating that the tax preparer in this case is also an attorney who should be aware of what the law is regarding distributions, because that falls completely.
So now now we have an added rule that if you're a tax preparer and an attorney, you have a heightened level of duty.
No,
that's
Your
what
Honor.
I'm hearing.
That's not what I'm saying. I'm saying in this context, in this case, where Mr. Broadman assisted the company in making distributions, knowing or being aware of the fact that he knew that the company was insolvent as the accountant, and he assisted them in making those distributions, that distribution was not only a violation of New York law, but the operating agreement itself has a restriction that squarely tracks the LLC law and says you can't do it if you can't make distributions if the company is insolvent. Mr. Broadman had that agreement. He read it, and he has to be held accountable.
Thank you. Counsel, you have 2 minutes in rebuttal.
Thank you, Your Honor. I just want to touch on a couple of the points. First, Mr. Broadman did not assist in making the distributions. The making of distributions may be prohibited by law and the operating agreement, but those transactions happen in the year prior to when a tax preparer sees them. All he did is properly classify them. In fact, plaintiff's expert actually stated in his expert report that the reclassification of those transactions as distributions was proper accounting treatment. So here, the plaintiffs are looking to hold Mr. Broadman and RBSM LLP liable for doing their job correctly. I think it's very clear that that is not substantial assistance, nor could that serve the basis as a legal duty to the plaintiff here. I think that Broadman as an attorney is inconsequential. He was not retained as an attorney. He was not paid an additional fee as an attorney. He has no obligations as an attorney to the plaintiffs. There's absolutely no reason why him holding a Juris Doctor and being on the retired rolls of attorneys for New York should increase his duty to the plaintiffs as a tax preparer.
Thank you so much.
Thank you, Your Honor.
Ninth Space LLC versus James Goldman and the Bluestone Group and DEG Investors LLC. Mr. Pauly, you have 6 minutes.
Good afternoon. We are appealing the lower court's decision to dismiss claims for fraudulent conveyance against the respondents. This court has said that when it comes to fraudulent conveyances, the economic substance is what matters most. We must ask, what are the practical implications? What is the economic reality? The transactions at issue in this case are complicated, and that's by design. There are many companies with similar names and many conveyances between those companies, all meant to conceal one basic economic reality. And that economic reality is that during this lawsuit, the Brother Jimmy's restaurant chain cloned itself. It dissipated all its assets to newly formed companies, controlled by many of the same people, at a time when the appellants and other creditors were trying to recover debts from Brother Jimmy's parent company, DEG. The respondents were a major shareholder, and they participated in those transactions and benefited from them.
My understanding is that the fight here was really not about whether a fraudulent conveyance claim could be stated, but whether it was stated and what you get to look to see whether or not it's stated, whether you're limited to the four corners of the complaint or whether you could go beyond that and look at additional materials and so what materials. Am I misunderstanding that?
You're not incorrect, Your Honor. And I would say that under either standard, we have pleaded a claim against the respondents, and the evidence confirms that we have pleaded a claim against respondents. I would say regarding what we have pleaded, the court has determined that the transactions that we're disputing are actionable and has allowed us to say that we've pled claims against every participant except the respondents. And we said a few things about the respondents that shows that they participated in these transactions and must have benefited from them, or at least pled a basis to infer, and we didn't get the benefit of that inference.
Isn't the problem, though, with the complaint itself, which is not to say you haven't stated a claim with everything else, but isn't the problem with the complaint itself is that there's not a clear allegation that this defendant was either a transferee of the assets or a beneficiary of the payments?
Well, I would respectfully disagree, Your Honor, in saying that we pled that the respondents were members of at least two LLCs, closely held companies, that still remain defendants below. And we allege in our complaint that the respondents had effective control over the equity and assets of those LLCs, which is to say they had dominion and control over relevant assets. And we also say that during this lawsuit, those LLCs transferred all their equity and assets to companies controlled by DEG insiders, including the respondents. And they did this to hinder DEG creditors from recovering on their debt. And I think that is a basis enough to infer that the respondents benefited from the conveyances. I think it stands as a common sense inference that they would not have allowed assets to leave the companies that they held with perhaps one or two other members if it were not to their financial benefit to do so. And the evidence—
Alternative argument, too, that let's say we find the complaint is not sufficient. Why should you otherwise withstand a motion to dismiss?
The respondents have not pointed to any controlling precedent or provision of the CPLR that required the trial court to ignore valid evidence that confirmed our theory of liability. And in fact, confirmed in great detail our theory of liability. And we've been seeking those documents in this case for many, many months from the original defendant, and we're unable to get them. They were introduced only as surprise exhibits in support of a motion to dismiss. And then we had to turn around and try to process those documents and figure out what they did. And we pointed to many aspects of those that confirmed our theory against the respondents, and the trial court should have paid attention to.
So your argument is that even if the complaint, you're arguing the complaint is sufficient, but even if the complaint's not sufficient, certainly if we were to look at the documents, that would be enough to plead or state a claim against these defendants.
Exactly so, Your Honor. That's our contention.
Thank you. You have time in rebuttal. Mr. Parnes, you have 6 minutes.
Thank you, Your Honors. May it please the court, I represent the Bluestone Group and DEG Investor LLC, Hillel Parnes Law Firm. I just want to start with some of the very things that Justice Kern was asking about. First of all, to be very clear, because my esteemed opposing counsel said this, there are some similar names here, and I want to be very clear about that. DEG is not the same thing as DEG Investor. DEG is still in the case. I don't represent DEG. DEG Investor is who I represent, and they're not in the case.
So let me ask you a question. Why, assuming, which I know you're arguing that the complaint itself is insufficient, why shouldn't the court consider these documents in making a determination as to whether or not there's a sufficient claim. But if the court does consider this document, why doesn't it remedy any deficiency that there may have been in the complaint?
Thank you for that question, Your Honor. So I'll work backwards because I don't want to lose sight of the fact that I think there is a deficiency in the complaint that we should not ignore. But working backwards, opposing counsel tries to say that the trial court ignored these documents. The trial court did not ignore the documents. If you look at the very long transcript of the oral argument, which begins at the beginning of the record, on which 3 different motions were on, mine was the smallest one, the judge did consider those 700 plus pages of documents. Now, I don't think opposing counsel should have burdened your record with them because they weren't relevant to my case. But regardless, they were
documents relevant to the issue of whether or not transfers were made to your client or that your client was a beneficiary of some of these transfers, since those documents directly pertain to those issues. Why shouldn't they be considered?
So working backwards, Your Honor, we actually do address all of that in the pleadings. We addressed it below. There were 5 things that opposing counsel pointed to in those 700 pages. We addressed each of them before we got in front of the trial court. And he now addressed 6 things this time around. We addressed the same 5 and the new one, the 12% issue. Because of the complexity, I don't think we have time to go into it in my 6 minutes, but they're all laid out in my brief. And I show, even if you consider these documents, they do not remedy the problem. They do not show So
let me be more granular then. Why don't the documents show that your client received certain things in exchange for the consent to transfer, which would state a sufficient claim under the Fraudulent Conveyance Act?
Thank you, Your Honor. So again, as we do address point by point, because they're very document intensive, we don't dispute that my client received things. We do dispute that the documents show they received things as a benefit of the so-called fraudulent conveyance. The so-called fraudulent conveyances are conveyances between parties that don't involve us, and at most, we are minority, not controlling. They're very careful in their complaint to say over and over again that Goldman is the controller. It was Goldman on both sides of everything. We are never alleged to be controlling anything. At most, we are alleged to be minority shareholders, not even of the companies that received or gave the benefit, but of the companies where the part of the benefit company that was transferred. So there's nothing in those documents.
That counsel, though, if there's clearly, these documents clearly establish that your client did receive things as a result of all these various conveyances, which is how all the assets left the company, why isn't that enough, at least at a pleading stage, to sufficiently allege that there's a viable fraudulent conveyance claim against your client?
Well, so again, let me make sure I say this so I don't run out of time. At the pleading stage, what we think they did is they actually affirmatively pled an aiding and abetting claim. And the Scheffner case from this court in 2015, and every case that's looked at, it says straight out, aiding and abetting.
I'm gonna, because we have limited time, let's not talk about the pleading stage. Let's talk about the documents. Okay, let's focus, because that's what the question is directed towards.
Understood. And again, I will direct you to my papers that talk about this, but just as by way of example, the 12% issue, right? They say we got 12% of a company, and therefore we got benefit, and therefore they've pled benefit. Again, they didn't plead it, but even if you conform it to the pleadings, what we point out by counter-referencing other documents in the record is on page 17 of my brief, Your Honor. I talk about this 12%, which is the new issue they raised. And we point out that they leave out documents in the record that say the 12% was acquired pursuant to a purchase agreement that was separate from these transactional documents. It was a separate document executed before these documents that conveyed the 12%. They plead in their papers for the first time on appeal, there's this magical 12%. They can't find it. We must have gotten the 12% as our under the table payment for being part of this. We show by counterpoint to the record that that 12% was under a purchase agreement that is referenced in the record that they don't reference and is not included in the record. So we can't look at it to see what it is.
Thank you.
Thank you, Your Honor.
Okay.
Am I out of time?
Yes, you are.
Okay, thank you, Your Honor.
So we have your briefs and your record.
Thank you very much.
You have 2 minutes.
I'd like to say just at the outset that I categorically reject the notion that we have omitted anything from the record. We've put in the record on the motions to dismiss, and we have cited to those documents only. I don't know what other document counsel's referring to. I think we're getting into fact issues at this point that show that if the court considers these documents or says that we have pled a case, we can get into this on summary judgment, but it's not for now. I would say also that we identified 3 transactions in our complaint. We got documents that concern those very same transactions, same dates, same times, a lot of the same assets conveyed, and that should be, at the very least, we pled enough to get a constructive fraudulent conveyance claim in. And I would point your honors to the Brennan decision, which recently came out from the First Department concerning these issues, which says, which addresses very similar circumstances where members of an LLC that was alleged to have made fraudulent conveyances were held potentially liable as a pleading matter so that the case could proceed. And that's all we're asking. We'd like a chance to get in there and use the documents that we know exist so that we can try to litigate a case. I would also point out, sorry, Your Honor, would you have a question?
No, go ahead.
I only wanted to say also that, the counsel says that we pled only that Mr. Goldman was the controlling shareholder. That is not true. We pled joint control, some form of joint control in certain entities between DEG, Mr. Goldman, and the respondents. At the time, we couldn't say respondents own 51% and have these contractual rights under the operating agreement, but the documents that were produced show that they had control over the relevant assets and that their participation and consent was necessary for these assets to go out the door. So if the conveyances are actionable and they had control and they acted and did it for material inducements and incentives in the form of cash, pledges, and liens, which are all conveyances under the New York debtor-creditor law, they should be held liable. And we'd like to pursue that.
Thank you so much. Okay. Pagniott versus Moore. Mr. Godofsky, you have 4 minutes.
Good afternoon, and may it please the court, David Godofsky for the appellant Parinas Pagniott. Your Honors, in a 2009 unanimous decision determining the application of the New York State and New York City human rights laws, this court held that these laws were enacted to combat discrimination within this state and city. When the Court of Appeals in Hoffman reversed the
Counsel, this is Justice Moulton. We got to deal with the Hoffman decision.
Yes,
it's been around since 2010. Both legislatures, the state and the cities, know about it. They haven't changed this jurisdictional rule. Why isn't Hoffman totally controlling on us?
Well, Your Honor, they didn't change the jurisdictional rule because it never appeared in the original text of the language that Hoffman interpreted. There is no residency requirement. There is no jurisdictional rule. This court held that there was no jurisdictional rule. There was a 4-3 decision in Hoffman, but they did issue or
so you just counsel, Judge Kern, there was a 4-3 decision in Hoffman. Even if we think Hoffman is wrong or incorrect or should be changed, we're the appellate division. We're not the Court of Appeals. How can we not follow a clear decision from the Court of Appeals? And I know you put a lot of emphasis that it's 4-3, but 4-3 is all you need to be the majority and to be the controlling law. So even if we agree with everything you're saying, aren't we bound by Hoffman, which is exactly on point?
Well, Your Honor, there are 2 points that are 2 responses to that. First, there was a revision to the New York State human rights law in 2019.
Yes, and it did not address this issue, as my colleague has already pointed out. Well, so we cannot act as the legislature.
Your Honor, respectfully, it did not specifically say we are overruling Hoffman, but it did emphasize that this human rights law is to be construed liberally for the accomplishment.
It has always said that.
It did not, the revision, Your Honor, it did say that, but it went on to say that exceptions to and exemptions from the provisions of this article shall be construed narrowly in order to maximize deterrence of discriminatory conduct. And that was added. And the whole issue of Hoffman was, are we looking at impact or are we looking at deterrence? The legislature in 2019 said the answer is deterrence. Additionally, impact doesn't work anymore because we're all sitting here. Ostensibly, we're at the First Department, but none of us are really at the First Department. And that's the way that the employment situation is evolving at a rapid clip, no more so than in 2020.
No, but this court has followed Hoffman during the course of the pandemic in Kingston, for example.
Correct, Your Honor. But again, reviewing the papers, no litigant has directly brought to this court this very point to address whether or not Hoffman is still viable in light of the amendment that says you should focus on deterrence.
Counsel, Hoffman is still viable until the Court of Appeals says it's not.
Your Honor, the First Department has said that it is not unheard of for this court to depart from established precedent when it is based on an out-of-dated remnant of a bygone era and no longer viable and in all respects inconsistent with the tenor of present-day tort law. Now, I know 10 years ago doesn't feel like a bygone era, but things have accelerated quite quickly. That's Adams versus New York City Transit Authority. However, Your Honor, Judge Manzanet, your point is obviously well taken. The court can still find against us and on its own motion grant us leave to the Court of Appeals under CPLR 5602.
You got a better shot there, Mr. Gaddafi.
Well, I'll take that shot. I'd love to go with response, but I'll go up with Mr. Mingione to Albany anytime.
Justice Kern, you wanted to ask a question?
No, I was going to say, you could make a motion for leave to appeal.
Precisely.
Expecting us to do it sua sponte.
I could do that, but I've got a matter of Johnson versus Martins and other cases where the court on its own motion granted under 5602A1 and allowing the aggrieved party, if they be so advised, to take leave to the Court of Appeals. I think it's very appropriate in this case. I think we should be focusing on deterrence. We shouldn't allow discriminating corporations to evade the strictures of the human rights laws simply because employees are becoming more and more attenuated from the geographical location of the New York City office.
Thank you so much. Mr. Mingione, we will hear from you. 4 minutes.
Good afternoon, Your Honors. May it please the court, may I just say, as an Albany, as a hometown, I'm happy to go with you, Mr. Godowski, if and when we get there. But the court appropriately said it all. 4-3 is all you need. Hoffman is the law of the state, and New York courts lack subject matter jurisdiction over claims where, like Ms. Pagniott, where people who neither live nor work in New York allege violations of employment discrimination laws, and the impact is not felt in this state. And I think it's important to mention that in addition to Hoffman, affirming the lower court's decision here will not leave the appellant without a remedy. Her policy arguments are misplaced. First of all, as appellant's counsel points out, yes, we're not sitting at the appellate division right now, but we're all sitting somewhere. And wherever we're sitting, the laws where we are working are the laws that govern us while we are working. So Ms. Pagniott could very well have brought a claim where she was hired to work and where she did work in Canada. And by not opposing our motion to dismiss the breach of contract claim, which was the sole tie to New York at all, impliedly there's no reason for us to be here. And that's why the lower court correctly held there was no subject matter jurisdiction over the claim.
Counsel, you concede, however, that both the New York State human rights law and the New York City law not only are to prevent the effects of discriminatory impact, but also, which Mr. Godowski pointed out, to deter conduct. And the employers are here in New York City, and so that's where the deterrence has to happen.
Well, that deterrence has to happen if they're held liable, if employers are held liable for the violating laws in other places. It happens all the time, and that is a deterrent effect as well. Ms. Pagniott, in this particular case, there may be cause to revisit Hoffman. It's not this case. First of all, this is pre-pandemic. I know it seems like a long time ago, but during the pandemic, as Your Honor pointed out, Hoffman has been reaffirmed and used. And Ms.
Why is pre-pandemic discrimination less harmful than post-pandemic discrimination?
No, but that's why the law.
I don't understand that argument.
Well, Your Honor, that's why the law doesn't need to change because of the pandemic. The existing rubric covers people who suffer employment discrimination in the jurisdiction.
Except that it seems pretty obvious that our world has changed as a result of the pandemic, and it is quite likely, none of us have a crystal ball, of course, but it is quite likely that there will be more, not less, remote working and working in between jurisdictions, as was the case here. So this is more likely to happen as time goes on, not less.
Whether it's more likely or not, Your Honor, it's not, Ms. Pagniott is not without a remedy. She had a remedy. And she also is pursuing a separate lawsuit seeking the same damages for basically the same facts against, Mr. Moore's wife, which is a pending lawsuit. So of all the people to be in a situation, she lived and worked in Canada not because of the convenience of the employer, which is when New York State has, for tax purposes and the like, would find someone to still be associated with New York, but in fact, for the convenience of Ms. Pagniott, who lived.
It was also for the convenience of the company. I don't think that's an accurate argument. She was there to build out the market in Canada, and building out the market in Canada is for the benefit of the company, not for herself individually.
Right, but for the benefit of, it was never intended for her. It's for the convenience of the employer. The job was in Canada and she was in Canada. That's where Canada has an existing scheme to redress these issues, and if she wanted to raise them, she could have raised them there. The contract between the plaintiff and the defendant is no longer part of the case and cannot confer subject matter jurisdiction regardless.
Thank you. Mr. Godosky, you have 1 minute.
Thank you, Your Honor. Respectfully to Mr. Mingione, I don't think that the courts or the New York State Legislature created the human rights laws so that we are outsourcing our policing of discriminatory behavior to other jurisdictions or other countries. It was McGeeva, the defendant, that inserted a choice of law clause to bring the claim in New York State. I think it's ironic what Mr. Mingione is referencing, that Ms. Pagniott has a claim for defamation pending in New York Supreme Court against the spouse of the CEO of the company, not an employment case, obviously, just a defamation claim, but is being barred on subject matter jurisdiction from bringing the claim against the employer, her employer, and the CEO in New York State. And with respect to a recent interpretation of the revision and this type of scenario, we reference in our brief at page 21 and page 22, it's Jarasaskite versus Almond Diamonds, where Judge Billings wrote that surely the New York State Legislature and the New York State City Council did not intend that a New York City employer would escape liability for creating a pervasive, hostile work environment that extended from New York City beyond its boundaries simply by targeting an employee who reported to the New York City employer what was assigned duties beyond its boundaries. That was June of last year. That is the trend. I would ask that this court, if it's not going to reverse, to send us to the Court of Appeals to visit this issue. Thank you.
Thank you so much. Lisa Vioni versus Carrie and Associates LLC. Mr. Carrie, you have 4 minutes.
Yes, thank you, Your Honor. Good afternoon. May it please the court, I'm Michael Carrie, attorney for appellants defendants. The court, during the cause hearing in this case, the court requested the parties to submit post-hearing memos on clawbacks. Carrie complied.
Counsel, let me just get
Ms. Vioni did not.
clarification. The judge didn't make any ruling on the disgorgement claim, did it?
I'm sorry, I didn't hear your question clearly.
What below did not make any ruling about disgorgement of fees? It only made a ruling about dismissing the counterclaims. Is that correct?
No, it also disgorged fees. And I have that. I'm going to address that, Your Honor.
I looked and I did not see that. That's why I'm asking. It appeared to me that although a request was made to consider that issue, that request was subsequently withdrawn. And it's not clear to me that the judge did address the issue of disgorgement. It looks like it only addressed the dismissal of the counterclaims, which is a different legal framework for us to consider than if there was a disgorgement issue.
But in this case, the error was in clawing back.
But where did the judge order disgorgement?
I'm sorry?
Where did the judge order disgorgement as opposed to just dismissing the counterclaims?
That is disgorgement alone, but in addition...
No, that's not disgorgement. That's dismissing a claim for fees that have not yet been paid. That's different than disgorgement. My question, if you want us to address your disgorgement issues, is where did the court rule that there should be disgorgement?
Your Honor, the court clawed back, contrary to law, which limits the clawback to, pardon me, limits the clawback to post-mistake services. The court clawed those services back. And in the...
Are you saying that services or clawed back fees?
Pardon me?
Are you saying they clawed back fees or
Yes.
they clawed back services?
Fees for services. My firm's fees for services to Ms. Vioni were clawed back by the court. In addition, the court clawed back...
Against you to pay those fees back?
Pardon me?
The court said you have to pay fees back that you received?
Effectively, yes. No. These are no. The court did not do that.
Well, that's disgorgement, counsel. That's why I'm totally confused.
I'm sorry, if I use the term disgorgement, that's not a term in our briefs.
So you're only talking about whether or not the counterclaims for legal fees that have not yet been paid should have been dismissed or not, correct?
That's part of it.
Well, then let me ask you, counsel, since you're not challenging the termination for cause, there was a hearing, the court held there was termination for cause, you're not challenging that aspect of the decision. Why then, once the court made that determination, would you be entitled to recover any fees based on the well-established rule that if you terminate it for cause, you can't recover any fees?
You can't recover for fees charged after the date of the mistake, which was the cause. But you can clearly, under the law, recover the fees or keep the fees that you billed for without any mistake and before any cause was established. In addition, what happened here was the court clawed back the pending counterclaims, which were counterclaims for services provided to Ms. Vioni prior to the mistake, prior to the date of the cause. The law limits, as I said, what I've said earlier. We're not seeking fees, as you clarified, Judge, for anything post-mistake.
Okay, you have some time on rebuttal. Mr. Stark, you have 4 minutes.
May it please the court. Thank you very much. Justice Kern, you're correct. There was no disgorgement. The issue was, and I raised it, whether we could make a brief for disgorgement. We elected to wait until the malpractice was decided, but the court did make a ruling that there was a termination for cause, and therefore the $100,000 of unpaid fees were not due and owing, and the counterclaims were dismissed.
And counsel, what's your response to the argument of opposing counsel that the only fees they lose are the fees that were billed after they made their error?
He's incorrect. There is well-established Court of Appeals decisions that reflect that if an attorney is discharged for cause, the attorney is not entitled to fees. That's Campanella, Teicher, and then there's also some
fees. Those are all fees, not just fees after the mistake. Is it?
Correct. And my adversary relies on a case called Decolator, and I believe I'm pronouncing that accurately, to support the proposition that it's only the fees after the malpractice. But he's got it completely wrong, because in that case, there was the attorney was disbarred for engaging in racketeering that had nothing to do with the case which he was seeking fees. And the court determined that he was entitled to fees before he was disbarred. But that was it. It said that it wasn't
to do though with termination for cause. Correct?
It had nothing to do with termination for cause. It had everything to do with disbarment. And my adversary relies on that case for the proposition that at the point of what the case indicates is that the lawyer should be paid up until the part of disbarment, because the conduct that led to the disbarment did not relate to the case, his representation of Farrell. And then there's a litany of other cases that my adversary relies on that say exactly the same thing. When someone's disbarred,
they're only entitled, if they were disbarred for conduct in the case for which they're seeking fees, then there would be a termination for cause, so they wouldn't be entitled to any fees. But in the cases where they're actually paid fees up until the point of disbarment, the disbarment does not relate to the representation. So if you look at the Nawaz case, which he cites to, the court says the disbarment is in no way related to the representation of Nawaz. But it certainly doesn't overturn the well-established case law that when you're terminated for cause, you're not entitled to fees. Unless there's any questions, I will rest on that.
Thank you so much. Mr. Carrie, you have 1 minute.
Your Honor, the mandamus was not, they relied upon a mandamus. The mandamus was not related to the termination for cause. Vioni did not argue at the hearing that mandamus was related to the termination for cause. No evidence in the record that mandamus was related to the termination for cause. And finally, the court did not state that mandamus was related in any way to the mistake or determination for cause. The malpractice argument cannot be brought because it was not a subject of the hearing. The relief we seek is the reduction of the clawback to $13,000, pre-mistake fees billed for services, and reinstate the counterclaims in the amount of $76,623. Also fees billed, but for services prior to the date of the mistake. Mr. Stark has, in our opinion, simply disregarded our law to the contrary of his argument, and the court should should grant the relief that we've asked for.
Thank you so much.
Thank you very much, Your Honor.
You're welcome. iPayment Inc. versus Andrew Silverman, Ms. Bosquet-Lambert.
Good afternoon, Your Honors. Bosquet-Lambert for Appellant iPayment. May it please the court. Appellant appears before this court today because the Supreme Court erroneously denied its motion for summary judgment in lieu of complaints, and this court should reverse the Supreme Court orders because, first, the good guy guarantee at hand is an instrument for payment of money only because it unconditionally and solely guarantees rent payment under a commercial lease, and there is no questions of facts that subtenant failed to make such payment for more than 2 years. Second, Appellant met its prima facie case by relying on the exact documents that are admitted by New York courts. Third, respondents failed to overcome Appellant prima facie case by asserting defenses that they expressly and unambiguously waived in the good guy guarantee. So I just want to highlight the fact that Appellant is not the landlord here, but the tenant. That means that when subtenant stopped paying, Appellant still had to pay its own rent to its own landlord. Moreover, when subtenant abandoned the premises in January 2020, and because of the pandemic measures, Appellant has been unable to regain legal possession and to relate the premises. So I now turn to my first point. The good guy guarantee is an instrument for payment of money only. So I refer the court to the plain language of the good guy guarantee at page 83 of the record. This is a language of an absolute and unconditional guarantee of rent payment as required by New York law. So I recognize that the guarantee also mentions the performance of any and all covenants. However, the sole covenants at issue in the motion for summary judgment in lieu of complaint is the payment of the rent balance. The other covenants are well defined in the good guy guarantee and covers obligations of subtenant arising upon expiration or sooner termination of the sublease. Here, the sublease has not expired and is not terminated. At all events, in application of the Stevens and the AFCO case, this good guy guarantee is still an instrument for payment of money only because it provides no prior performance by appellant.
This is Judge Kern. Before you run out of time, do you also want to address the warranty of habitability and the executive order arguments?
Yes, Your Honor. So I want to address the fact that respondents waived any defenses. So they cannot assert any defenses. I refer the court to the plain language of the waiver, the defense waiver of the good guy guarantee at page 86 of the record. And it shows that they waived any defenses other than payments. And at all events, the balcony issue, the fact that subtenant was not able to use the balcony for a few months occurred 8 months prior to the default. And the fact that the AEC was malfunctioning for a limited period of time occurred 2 months after the default started.
What about the executive order argument about COVID?
Yeah, because of the executive order about COVID, we've been Appellant has been unable to relate the premises. And
what is the issue that there's a stay of this whole thing because of the executive order?
Yes, absolutely.
Which is an argument that's being made.
Yes, absolutely, Your Honor.
What's your response to that argument?
We could not. My appellant has been unable to regain legal possession of the premises because of this executive order, Your Honors. And that's why appellant has been unable to relate the premises.
Thank you.
Thank you,
Mr. Kaplan, you have 4 minutes.
Thank you. May it please the court, Your Honors. My name is Stephen Kaplan from Kaplan Levinson. I represent Andrew Silverman and Alexander Silverman, the respondents. There are 3 fatal reasons.
Isn't this an unconditional guarantee? It looks exactly like an unconditional guarantee to me. What about it makes it not unconditional?
Okay, Your Honor. The guarantee is at page 83 of the record, but the reason that the guarantee is not a guarantee that is susceptible to CPLR 3213 is because it's not a guarantee of payment. It is a guarantee of payment and performance. And this court held
and severable clear provision that guarantees payment, which is separable from any other provision having to do with performance.
Every
contingent on any performance or lack of performance.
No, well, I actually, Your Honor, I think if you look at Dresden Bank, that case, and you look at the Associated versus Liechtenstein case, those were cases, among others, where whenever there was a guarantee of performance in addition to a guarantee of payment, both departments, both the first and the second department, ruled that a 3213 procedure was inappropriate. Every case that the plaintiff respondent relies on, it was pure guarantee of payment.
Counsel, isn't the standard for an instrument of the payment of money only whether you can determine, taking it away from guarantees, whether there's an obligation for the payment of money only, which can be determined just from looking at the 4 corners of the agreement? That's this test. So why wouldn't this meet that test in all respects?
Because Your Honor, that is the nature of the inquiry, and in this case, it fails in every way. And here's the reason. According to the plaintiff respondent, there's a guarantee. Okay, then in order to ascertain the relief that the plaintiff is seeking, you would have to read the sublease, and then you would have to read the overlease, because the overlease is where the plaintiff is seeking to piggyback off the remedies and damages provisions, which they don't apply, and I'll get to that in a moment. So now you'd have the overlease, you'd have the sublease, you'd have an affidavit of non-payment, you would have the payment ledger, and then you would have the prospective damages that the plaintiff is seeking. That is the textbook definition of what a 3213 motion is inappropriate for, when you need to go to that many documents.
For people, the courts consistently hold that guarantees can be instruments for the payment of money only. So I'm not sure why this case is different from any of those cases.
I don't think there's any dispute that there are guarantees that can be for the instrument, that can be an instrument for the payment of money only. This one, however, is not, and there's multiple reasons. One, like I said, is that fact that it was a guarantee of payment and performance. 2 is, in order to ascertain the relief, according to the plaintiff's own arguments, you must read the overlease, the sublease, the affidavit of default, the 8 exhibits that were also added to the that attached to the motion, and you've now entered the realm where, to use the words of there was a quote about, and I'll tell you what case it was, Your Honor, that this is exactly what 3213.
Counsel, you have 30 seconds left if you want to use
Then
them.
let me point out one other thing, Your Honor, because according to the plaintiff, the damages that they've asked for is all of the rent through the end of the term, legal fees, interest, and late fees. But if you look at the record, page 44, which is the overlease, that's the damages provision that they're seeking to piggyback off of in the sublease. There's a formula for what the damages are, and the damages that they're seeking on in record page 14, the affidavit of Philip Ragona, has no bearing on the damages formula in the overlease, which talks about the diminution in the present value of the rent stream payments reduced by the diminution in value by the present value of the rent stream payments. The plaintiff's damages request has no bearing on that. There's no right to attorney's fees. There's no right to late fees. Nothing in the sublease is silent about it. And that personifies why a 3213 motion is inappropriate here. The damages are just completely unsustainable.
Thank you so much. Ms. Bosquet-Lambert, you have 1 minute.
Thank you, Your Honor. So I would like to respond to Mr. Appellant on 2 points. So first, Appellant relied on the exact documents that are admitted by New York courts. So the Appellant relied on the lease papers, the good gag guarantee, and an affirmation of non-payment. Those are the exact documents that have been admitted in cases such as the Spring Prince or the 1277 cases where summary judgment in lieu of complaint was granted. As for the computation of damages that is disputed by respondents, I refer the court to the plain language of the sublease, page 71 to 73 of the record. So it shows that the lease is incorporated to the sublease, and it also describes with precision the provision of the lease that are excluded from the sublease, and it does not mention the provisions on damages. Therefore, the computation of damages provided by Appellant is correct in application of the lease as incorporated to the sublease.
Thank you so much.
Thank you, Your Honors.
And last but not least, recalling Artists' Rights Enforcement Corp. versus Joseph Robinson Jr. Mr. Klein, are you there now?
I am. Can the panel hear me?
Yes, and you owe your adversary an apology for not being available earlier. You have made him wait an additional 30, 40 minutes.
Well, I do apologize to Mr. Cordero, and by the way, it's very nice to meet you, Mr. Cordero, and I apologize to the court. I kept clicking the unmute, and I guess I have to take the issue up with Microsoft, so I apologize.
We have had the same issue. You may proceed, sir.
Thank you. So may it please the court, Gerald Klein from the law firm of Taylor English Duma. Bless you, Your Honor. And I have 3 topics to address very quickly here in the time allotted to me, which warrant a reversal of the trial court's partial grant of summary judgment to AREC, or ERIC, as I'll refer to it. The first issue deals with the core determination by the trial court that the agency relationship between the artists and AREC was one that was a agency with a power coupled with an interest.
Counsel, why do we even need to address that issue, to be quite frank? Why wouldn't they be entitled, based just on the language of the settlement agreement itself and the provisions of the settlement agreement itself, which clearly provide that the defendants are not entitled to rely on any revocation from Glover and Morris without any communication with ARCC. I mean, it clearly provides that they're not allowed to take away their authority. So why do we even have to address the issue of agency coupled with an interest?
Well, you have, Your Honor, you have intervening situations coming in 2010 and after the 2007 settlement. You have a on-the-record settlement arrangement confirmed by the court, and you have basic agency law that provides where agency situations can be revoked. And one problem here.
agreement specifically says, no, you can't do it without consulting with ARC. You cannot have a revocation. And it's a binding settlement agreement in open court. So why isn't that provision binding that says, in this case, no revocation?
Because that agency, however it may have been stipulated or characterized in a settlement agreement, is not an agency coupled with an interest. And because it is not an agency coupled with an interest, Your Honor, the principal has the right at any time to modify it, extinguish it, diminish it, or terminate the relationship. And as long
as enter into an agreement that takes away that right. I understand that that's normally the right, but if there's a specific provision in the settlement agreement that says, no, that rule does not apply here, why shouldn't that be enforceable?
And let me add as a friendly amendment to that question, especially here where the settlement is entered in open court in the middle of a trial, and the court permits the trial not to have to continue to its completion because of the settlement. Why should the parties then be allowed to not honor that settlement?
In part, Your Honor, an issue arises where the revocation in the summer 2010 is sent out by counsel for the artists, for Mr. Glover and Mr. Morris, and it is received by our clients. And as a result, Eric subsequently learned somewhere down the road about this situation. And there was, in fact, discussion between the parties pursuant to what's in the record. So that wrinkle creates a question of fact.
Question. The agreement, the settlement agreement, specifically incorporates the 2004 rider, which specifically provides that defendants are to deal directly and solely with plaintiff and would make all payments solely to plaintiff. So that's a specific provision in the 2004 rider, which is incorporated into the settlement agreement. So why isn't that an enforceable agreement which prevent the argument you're making now that you're entitled to rely on any subsequent acts by Glover and Morris?
It becomes a question of fact for a jury, Your Honor, in terms of what was the intent of the parties.
But counsel, that's an ambiguous provision. It says that you have to deal with them directly and you have to make payments to them directly. What's there for a jury to determine? Why isn't that an unambiguous provision which the court can enforce?
It becomes a question down the road in 2010 when Morris and Glover take an affirmative step to formally advise my client that the agency had been terminated. So there are those facts that come into play.
How can your client rely on, I'm asking the same question again, but how can your client rely on any statement by Glover and Morris where the agreement specifically says that you are required contractually to deal only and solely with plaintiff and they'll make all payments solely to plaintiff? So once you have that, how can you rely on anything that Glover and Morris say to you except your own detriment?
Well, our client undertook to protect itself, just given the evolution and duration of this whole case.
Was a declaratory judgment action started in order to settle this issue? If indeed there was a good faith basis to question whether this was still enforceable, why not institute a declaratory judgment action and get the question answered by a court rather than violate the obvious and clear language of the settlement agreement?
Well, I think given the tenor of the relationship with the parties over time and given the situation that Sugar Hill is now hearing in 2010 that there is an end to the agency, it commences paying and believed that it was doing so in good faith. And certainly under New York law, as a third party, not a party to the agency agreement, it would be allowed to do that. And of course, if there was an issue, the agent...
Counsel, it's a party to the settlement agreement. So it is bound by the provision in the rider. So it's bound by that agreement, which says it can't do exactly what it did.
Your Honor, again, I think there are factual questions that come in once an actual written revocation through counsel for the artist step out in the summer of 2010 and say, heads up, Sugar Hill, you no longer are obligated to make payments.
Somebody go to Eric and say, what's going on? What's happening here?
Well,
the settlement agreement has to be doing this?
Again, Your Honor, we can speculate what could have and should have been done back then, and we can speculate on how, given the relationship of the parties and the acrimony over time, may have driven that. But
all the more reason why they should have gone in for a declaratory judgment action. You'll have 2 minutes on rebuttal. I will hear from you, Mr. Cordero.
Thank you, Your Honor. And may it please the court. And, Justice Kern and Your Honor, Justice Daniels, you hit it right on the head. We don't even need to get into the issue of interest and agency. It just goes straight to what's actually the parties agreed to over numerous litigations and culminating in the 2007 settlement agreement, whereby it was just between Eric and the defendants, artists' rights, which are referred to as Eric, and they agreed to directly and solely pay Eric the royalties that were due to clients. And the defendants performed under that 07 settlement from 2007 to 2010, and then they just unilaterally decided to stop performing. And like Your Honor, Justice Daniels said, they should have seen declaratory judgment action, but didn't. And so they bear the brunt of when you, as a breach, when you stop performing, of what happens. And just so it's clear, the two components of the settlement was that there was a payment structure for past due royalties, and then an obligation to payment, disclosure, and reporting obligations going forward for royalties and license agreements earned or entered into after the agreement. And as the court pointed out, it incorporates the rider from 2004 and the settlement agreement from 2003 that was signed by the defendants in question and the two songwriters in question, Mr. Glover and Mr. Morris. And as the court has pointed out, it's that in paragraph 26 of the rider, it's crystal clear for all, which is at record 191, for all matters related to the action or the compositions thereunder, defendants shall deal directly and solely with Eric. That's an obligation, that's an agreement, and if they don't do that, it's a breach. Also, as Justice Kern pointed out, and also in the same rider in record 187, it says, provides that Eric will be responsible for receiving, distributing any payments due under the agreement. And then once payments are received, defendants have no further obligation or liability to the plaintiff or the songwriters regarding receipt of their portion of such payment, end quote. And that's a key in Justice Daniels when you talk about declaratory judgment. Under this agreement, defendants were basically released from any further obligation to the songwriters if they performed for Eric. So there was no reason to even rely on these letters that happened in 2010. And so they just simply didn't want to do it. And once again, in the settlement agreement, just so it's clear to button it up, and from 2003, section 7.1, which is at record 137, quote, Eric is irrevocably appointed as their, being the songwriters, duly authorized representative, end quote. And like I said, it's a settled, that was signed by the individuals involved. And then also to make it even clear, Mr. Glover and Mr. Morris submitted declarations in the prior federal action, which is records 112 and 115, once again, quote, stating, they designated and warranted and represented that Eric was irrevocably appointed as mine, duly authorized agent for all purposes relating to the lawsuit with Sugar Hill and the Robinson defendants, end quote. Then even even more, on April 15, 2013, there was a parties executed as so ordered by the district court an agreement, which is available at record 117, and is stating that Mr. Glover and Mr. Morris reaffirmed that Eric is, quote, is their irrevocably appointed authorized agent. And then finally, to put any doubt, Mr. Glover and Mr. Morris in 2012 signed letters of directions, which is available at record 217 and 224, saying the same exact thing. So you have the record is filled with proof of the appointment, as the court pointed out. This was an agreement. This was the evidence of agreement over a number of years, and defendants simply chose not to perform, and therefore they are in breach of the agreement, and the decision below should be affirmed. Just quick points, just also clear, because there's some questions. The back due settlement of back due royalties for $268,000, that was not the only payment obligations. That argument was made on the first time in appeal, not in the court below in the motion for summary judgment. And once again, to button it up, the settlement agreement from 2003 had three clear obligations. Oh, basically first, on the section 5.10, which is in the record 134 to 35, that's for the payment of past due royalties. Then also in section 5.1, which is at record 132, that's the right of the defendants to exclusively administer and exploit the compositions in question going forward. In exchange for section 5.2, defendants' obligation to pay the songwriters their pro rata share of the income generated from those compositions, and that payment has to be for Eric. It's a balance. The defendants will not have the right to continue to exploit these compositions without having the obligation to pay, and they have to pay Eric. And they stopped doing it in 2010, and therefore they're in breach. And counsel did not bring up the issue on liquidated damages, but they just briefly, if I had more time, and the court below was absolutely correct on this. The defendants simply can't meet the standard for saying that this was an unenforceable penalty. Court of Appeals instructed under two circumstances: damages that either the damages are readily ascertainable at the time of the contract, or that liquidated damages is conspicuously disproportionate to foreseeable losses. There's no evidence of that in the record presented by the defendants. And remember, at the time of the 07 open court settlement, during trial, as Justice Daniels pointed out, they couldn't predict what the licenses were earned, or the songs, the compositions were earned in the future. So, and then therefore, that's why Justice Freeman opined on the settlement and called it the liquidated damage provision, quote, was a good idea. And so thank you, Your Honor, and thank you for your time. And for these reasons, the order should be affirmed in its entirety.
Thank you so much. Mr. Klein, you have 2 minutes.
Thank you, Your Honor. I will address the liquidated damage issues. This 20% bonus is clearly a penalty provision. That is underscored even as a matter of law, and Sugar Hill moved for summary judgment on that topic, declaring that it was a penalty provision, and asked the court to throw it out as a penalty rather than liquidated damages. It doesn't fit the mold of liquidated damages clearly under New York law, not even down here in Georgia law, which follows the same pattern. What it does, it creates a 20% number that has to be multiplied against some other number to create a dollar amount. Well, what's that other number? The other number is a calculation that is described in the order and decision of the trial court, wherein Eric came to the court and said to the trial court, well, we have records, and according to our records, there is $516,373.83 in damages that is due by reason of these alleged breaches by Sugar Hill. If it could calculate that number absolutely down to the penny to 83 cents, it's able to calculate a liquidated sum, and that basically drives the state through any claim that this provision is liquidated damages related and not a penalty. If a liquidated damage clause in the usual vernacular that all we lawyers understand, it's an amount set in a contract in advance of breach, leading up to execution, that designates a number that the parties reasonably believe will be adequate damages because they otherwise can't be keenly or accurately calculated. We don't have that targeted first starting point in this case. Moreover, what the trial court said was this bonus is an incentive for Sugar Hill to perform, and if there's a breach, there may be other royalties due that Eric did not know about that. My response to that is that an incentive to perform, if it is not performed, becomes a penalty upon a failure to perform. So I would ask. Thank you so much. Thank you. Thank you, Your Honor.
Thank you. Have a good day. This concludes the session of the Appellate Division, First Department. Good evening, all.